I'm going to discuss in this video my thoughts on Trump's New York felony trial that is scheduled to start on Monday. This will be in more detail than my previous video on this subject that I will link in the More section below. If convicted, Trump could face up to 4 years for each of the 34 felony counts if convicted on all of them. It is my understanding that paying hush money is not itself illegal. I haven't researched the issue, but that makes sense to me. Basically, the New York prosecutors alleged that Trump reimbursed Cohen for the payments Cohen made to the porn star Stormy Daniels, who claimed to have had a one-night stand with Donald when he was married to Melania. That is by itself not illegal either, provided no business records were falsified to cover up the hush money payment, which was in fact done. The hush money payment to Daniels was fraudulently classified as corporate legal expense, and that documents relating thereto are the fraudulent business records. A detailed chronology of the facts in this case can be found in an article titled, quote, Detailed Timeline of Trump Hush Money 2016 Election Investigation, end quote, published at the Just Security website. The statements contained in that article are supported by links to other material, which anyone can review. The willfully ignorant will, of course, remain so by choice. Under New York law, falsifying business records by itself is a misdemeanor, not a felony. But it can become a felony, which Trump has been charged with committing, when there is a, quote, intent to defraud, end quote, that includes an intent to, quote, commit another crime, or aid or conceal, end quote, another crime. The other crimes alleged by the prosecutors involve violations of election laws, including exceeding the federal campaign contribution cap. Trump claims that the case is a sham and some kind of election interference scheme hatched by radical left Democrats and their leader, President Biden. No proof is offered by Trump, which is normal for him to support those kind of accusations. He just makes them, and they are believed by tens of millions of people. As with all such claims made by Trump regarding the civil and criminal cases that have been filed against him, belief in his characterization of them is dependent on viewing Trump as honest. And it must be accompanied also by a refusal to look at the evidence with an open mind, which Trump supporters are incapable of doing. Trump can remain assured that his supporters will not look at the facts supporting the civil and criminal cases. Ask yourself this question: why would Trump have Cohen make the hush money payment to Stormy Daniels after the Access Hollywood tape was released in early October 2016, and then conceal the reimbursement as legal fees? If Cohen had disclosed the payment as a campaign contribution, which he should have done, that would be equivalent to broadcasting nationwide shortly before the election that Trump was arranging a hush money payment to a porn star. Not a good idea after many voters were still reeling from watching Trump bare his real soul on the Access Hollywood tape. The DA will be able to prove that the records were falsified to cover up the hush money payment. The payments made to Cohen to reimburse him were falsely classified as legal expenses. Trump signed at least 2 of the checks. The first factual question is whether there will be sufficient proof to connect Trump to those falsified business records using the guilt beyond a reasonable doubt standard. The second factual issue is whether there will be sufficient proof that the falsified records were created with the intent to conceal another crime. The other alleged crimes involve campaign contributions. The first legal issue is whether the hush money payments were campaign contributions. I believe that Trump will lose on that issue. If the payments were campaign contributions made by Cohen and the National Enquirer in connection with their payment to the Playboy centerfold model Karen McDougal, both had to report those payments as campaign contributions, and both exceeded the maximum allowed. And of course, neither Cohen nor the National Enquirer reported those payments as campaign contributions. Trump would also have to report using his own funds, including funds from his trust, to reimburse Cohen for the Stormy Daniels payment, based on the agreement to reimburse him made prior to the election. See, quote, using the personal funds of the candidate, end quote, published by the Federal Election Commission. The National Enquirer admitted that it violated the election law with its $150,000 payment in a plea deal that it entered into with prosecutors, which included a commitment to provide honest testimony against others involved in that scheme. See article titled Publisher of National Enquirer Admits Paying Hush Money to Help Trump Ahead of 2016 Election, end quote, published by NBC News on December 12, 2018. Cohen also pled guilty to campaign law violations for his role in the hush money payment. See Michael Cohen sentenced to 3 years in prison, press release dated 12/12/2018 from the U.S. attorney who made this statement, and I'm quoting. Cohen caused American media, which was identified in previous court filings as Corporation Number 1, to make a $150,000 payment to one woman. In the other, Cohen made a $130,000 payment to another woman through an LLC he incorporated for purpose of making the payment. Cohen was reimbursed for the latter payment and monthly installments, discussed as payments for legal services performed pursuant to a retainer, when in fact no such retainer existed. Cohen made or caused both of those payments in order to influence the 2016 election and did so in coordination with one or more members of the campaign. End quote. The defense may argue that there was no criminal intent to evade election laws, but that Trump was merely a victim of extortion, and he made the payments or caused the payments to be made to keep his wife from learning that he allegedly cheated on her with a porn star and a Playboy centerfold model. Other arguments may be made. We'll just have to wait and see what they're going to try to do. Maybe those kind of arguments will convince a juror or two. They're certainly worth making for the defense. But for campaign finance law violations, it is my understanding that it will not matter whether Daniels and McDougal were telling the truth about their extramarital affairs with Trump, if the payments to them were in furtherance of the campaign and were made with the intent of influencing the outcome. I view those arguments that the defense will make as being smoke and mirrors in the context of Trump becoming increasingly concerned in 2016 that too many Christian evangelicals would abandon him in droves upon learning about these extramarital affairs with a porn star and a Playboy centerfold model just before the election, and also in the context of Trump revealing his true nature and character in the Access Hollywood tape. So in that context, the hush money payments were in furtherance of the campaign and had to be reported as campaign contributions, and they could not exceed the limit for those kind of contributions made by Cohen and the National Enquirer. The prosecution does have a problem in making evidentiary, meeting their evidentiary standard of proof to the extent they have to rely on Cohen's testimony. It really depends on how much of his testimony is backed up by documents and other witnesses. There are two big evidentiary hurdles that I see using the guilt beyond a reasonable doubt standard. The first will be to connect Trump personally to the creation of the falsified business records, and then to prove that his intent was to commit another crime or to aid or conceal another crime. Based on what I know now, it looks like there will be evidence sufficient to connect Trump to the creation of falsified business records, which, if that is it, on the proof is a misdemeanor. The second issue will be more difficult for the prosecutors to prove the intent to defraud in order to conceal another crime. Jury nullification is always a possibility when it comes to criminal charges against Trump. I think, in a way, 75 million of his supporters have been nullifying evidence now for 8 years. It only takes one juror to ignore the evidence and the judge's instructions and vote to acquit, irrespective of whether or not the prosecution carried its burden of proving guilt beyond a reasonable doubt. The payments were made at a politically vulnerable time for Trump, and the timing provides some proof of the relationship to his campaign and being in furtherance of his campaign. The Access Hollywood tape was released on October 7, 2016. On October 27, 2016, the $130,000 hush money payment was made by Michael Cohen through an LLC that he created just for that purpose. Cohen sent the funds to Stormy Daniels' attorney and classified the payment as a legal retainer. The other woman that I've been mentioning, Karen McDonald, who was a Playboy centerfold model and Playmate of the Year, claimed in 2016 that Donald had an extramarital affair with her after his marriage to Melania. During 2006 and 2007, I believe she claimed it lasted for about 10 months and then she broke it off. Trump had married Melania on January 22, 2005. So if Karen McDougal is being honest about her claim, she is describing an extramarital affair with Trump. McDonald was interviewed by Anderson Cooper on CNN, and a video of that interview can be found here at YouTube. The title is, quote, "Playboy Model Speaks Out of Time with Trump." May have written that down wrong. McDonald was talking about disclosing the alleged affair in 2016. The National Enquirer, that was supporting Trump, acting in concert with Cohen, paid her $150,000 for her story. She kept quiet about it and then killed the publication. This is called Catch and Kill. In a meeting with Trump, and this is important, Cohen recorded the conversation. They talked about reimbursing the National Enquirer for the $150,000, basically purchasing the contractual rights of the Enquirer to kill the story. An agreement was prepared for a $125,000 payment by Cohen to the Enquirer, with Trump reimbursing him. And he was going to claim falsely that this was for advisory services that he rendered to the National Enquirer. But the National Enquirer's general counsel got wind of this and killed it, and rightfully so. If convicted, Trump could face up to 4 years in prison, as I said, on all of the 34 charges. Even if he is convicted, the verdict will not be final until all of his appeals are exhausted, which will not happen before the election. If elected, I doubt that a state judge would sentence a sitting president to jail for the crimes that will be tried starting on Monday. And even if he did give them some jail time a few years down the road, there would be a federal court challenge by Trump's DOJ if he was the president, challenging this that the state court lacked the authority under the separation of powers constitutional doctrine to imprison a sitting president. While that may not work, it would still delay the jail time by a very lengthy period. People who call themselves evangelical Christians overwhelmingly support Trump. That does say a great deal about them. If they have not changed their opinion about Trump after 8 years of viewing him in action and reading his comments and his everything else that goes on with him, they're not going to change their opinion about voting for him just based on a felony conviction or even multiple felony convictions. I think that would only make them more angry and more disturbed about Trump being charged in the first place.